Thank you, Your Honor, and may it please the Court. Counsel. My name is Erich Priebe, and I'm here with Attorney Dave Dutton on behalf of the protesters in this case, Mark Alcorn and Paula Tyler. This is a case that invokes our guarantee of equal protection of the law under the Iowa Constitution. Iowa's inheritance tax laws discriminate by granting privileges in the form of inheritance tax exemptions to one class of stepchildren, while at the same time imposing a heavy tax on another class. At its core, Iowa's Equal Protection Clause means...
Question. According to Webster's dictionary, a stepchild is a child of one's wife or husband by a former partner. Now, by that definition, Mark and Paula were not stepchildren after Donald was divorced, correct?
I think that's correct. However, that wasn't the operative definition for purposes of inheritance tax prior to the legislature making its enactment in 2003 and dividing up the class of stepchildren. So in this case, we're really looking for a valid reason for treating these different types of stepchildren differently. And we assert the legislature had no valid reason under Iowa's Equal Protection Clause, so we're asking the court to reverse the lower courts and strike the definition of stepchild that's set out in Iowa Code Section 450.1 sub 1E. Now, I think it helps to understand just how the statute works, and the definition itself is set out along with a background at the brief, pages 11 to 14. But consider this: the tax operates by looking at what you can call the horizontal relationship between the parent and the step-parent, but it imposes a tax based on the horizontal relationship, or sorry, the vertical relationship between the step-parent and the stepchild. If, for example, the horizontal relationship between parent and step-parent ends with the death of the step-parent, here in the top example, then a testamentary devise to the stepchild is tax exempt. If the horizontal relationship ends in the death of the parent, again, a testamentary devise is exempt. It's only in this third instance, where the horizontal relationship is terminated by divorce, that the devise from the step-parent to the stepchild is taxed. And in fact, it's taxed at the highest rate, as if this individual was a collateral or unrelated person, almost like a stranger.
But are they still similarly situated once the divorce of the step-parent and parent comes to fruition?
The question of whether they're similarly situated is a difficult one, because remember, the standard is, are these individuals similarly situated with respect to the purposes of the law? And that's from the Racy 2 case, and it's cited by the department. That's problematic because we don't know of a purpose of the law.
I mean, could we say that the purpose of the law is to protect and promote family relationships and families? Isn't that generally the purpose of these kinds of exemptions in different tax laws?
It may be, but I think that's troubling, and this is a rationale that's been explored here through this litigation and by the lower courts. If, in fact, the purpose of this definition and this inheritance tax law is to encourage closeness or a close family relationship, remember, in fact, this statute narrows the tax exemption and imposes more taxes than before. So if the purpose is to incentivize human behavior and to create some kind of a closeness through the tax code, it couldn't do that. It's imposing a tax.
Let's say it's to incentivize people. Let's say, you know, we have things like family farms, to keep those family farms within the family. Generally, an exemption that works for lineal descendants would be something that would promote that in, wouldn't it? Isn't that right?
It may well be. But again, part of the problem is you have to ponder why exactly, in this instance, the government has any sort of a legitimate interest in the constellation of a family.
What interest do they argue?
The interests we've seen and explored here in this case, I think there are 8, and for the court's benefit, those are set out one by one, pages 19 to 20 in the brief. The first one that we've addressed is the interest in the purpose of raising tax revenue. Of course, our response here is that that cannot be an answer.
I agree with that one. But the problem I see, and maybe I'm being repetitive, but when you have a divorce, which is in your last scenario, the family structure is now significantly changed. You don't have the kind of the same family structure that you had before when you had the parent and step-parent married, obviously. And could the legislature decide, well, although this is very rough classification, but in those situations, we are not going to assume the tight relationship between the step-parent and the child continues, and we're going to subject it to a different kind of taxation?
I can understand the rationale, however, I don't think it makes sense, and this is why. Remember, if the legislature is acknowledging that the relationship is somehow different, it's imposing a tax where, in this one circumstance of the 3, the relationship has apparently remained the same. It only taxes, and the statute only operates if there's that dotted line, if there's a bequest.
But divorce changes things in general. I mean, for example, you're not complaining about the fact that the testimony transfers between Donald and Constance are going to get taxed as if they were made to strangers, right?
That's not the issue in this case, that's right.
And I mean, laws don't have to have a perfect fit to meet the demands of the rational basis test. So isn't it reasonable for the legislature to assume that divorce changes things also as to children of the ex-spouse? In many cases, they don't. Apparently not here in terms of the personal affinity between the people, but in many cases they do. Isn't that fair?
It's not exactly comporting with the Equal Protection Clause because, again, it only operates where there is a bequest. Where there isn't, for example, a continuing close relationship, the statute has no effect because there's not a bequest upon which it can operate.
But
Well, to me, again, the entire legal relationships change once you have a divorce, and so you have sort of the benefits are different, and then the consequences are different. And to me, this appears to be, and you have a pretty strong burden to try to overcome a rational basis for the legislature believing that these ought to be taxed differently. And don't you see a difference in the legal relationships that the legislature could also find?
Well, there's a change, but I don't think it's a change that warrants the disparate treatment. Another example, and I think a concern that I'm
But
hearing...
that's kind of a policy argument that you're making. You know, you don't like it, you don't think it's fair, but isn't there a rational basis for doing that just based upon the mere fact that there's now been a complete change in the legal relationship between these people? They're not necessarily, to me, similarly situated any longer.
What the Equal Protection Clause requires, even under rational basis review, is that we assess the means and then the ends to achieve them. And I think the sentiment that I'm hearing from the court has those means and ends backwards. Because we know, for example, individuals are not basing decisions about how they're going to structure their family or how they're going to be close, who they're going to form relationships with, based on incentives in the tax code.
it's not just the incentive argument is one argument, and that's an argument. But it's not just the incentive; it's just preserving the family's wealth, keeping the family financially secure. Now, let's say, as often happens, you had a blended family, and Donald had his own children, and Donald passes. The state might say, well, it's important for us to make sure that Donald's children are taken care of, because, and to incentivize Donald to take care of his own children, because Constance's children are going to have a separate family members that are going to be able to take care of them. What's wrong with that?
Well, for one, if you look at this diagram and how the code operates, it has no consideration. It doesn't matter what's happening on the other side of the parent and the child. What else is happening in the family is not taken into
See,
consideration.
you're arguing policy and unfairness, but all the rational basis test under RACI requires is the ordinance serves a legitimate government purpose, which is realistically conceivable, and I think by preserving the family unit and preserving assets that family unit may have developed during their marriage, it's conceivable. Then you have to say whether or not the claimed relationship, the claimed reason has a basis in fact, and in fact, it seems to me it may, for the simple reason it does that, because you don't pay the tax and you may not have to sell the farm. And the third test is it so attenuated, and I don't see it attenuated. So even if you apply the stricter RACI test, I mean, we could talk about what's fair and what's not fair. I mean, it'd be unfair if after this divorce, the biological parent married a millionaire, and the stepkid gets it from the first family and the second family. I mean, we could think of all kinds of things, but that's not the test whether it's fair or not fair. That's what our equal protection's about. It's an application of the three-step process, and apply to me the three-step process and tell me why it doesn't meet rational basis under RACI.
Okay, with the first step, we're talking about, is this a legitimate government interest? And I think the interest we've spent the most time on here this afternoon is fostering a closeness or a certain core of a family unit. That's problematic. If you look at Varnum, for example, one of the first government interests that this court rejected was a certain, what I'll call, constellation of individuals in a family unit.
No, I read completely the opposite. I think Varnum is consistent with this. In other words, Varnum, we said, preserving and protecting the family and assuring the security of the family is such an important interest that it should be available to everybody, whether it's a same-sex relationship or an opposite-sex relationship. Mm-hmm. You don't read Varnum that way?
I don't necessarily disagree with what you've said, but I disagree about the effect of Varnum in this context, because the stepchild in the bottom box there, in the bottom example, and the stepchildren sitting behind me were family, and they were discriminated against based on the inheritance tax code. That's my general response to the first step.
That's the purpose. Now tell me why it's not conceivably in fact.
Is it conceivable, in fact, that this statute would encourage closeness or encourage a certain family unit? Again, I don't think so, because people don't make decisions about who they're close to and who they consider family and who they care about by consulting Iowa Code Chapter 450. The means and ends are backwards.
Let me ask you this. Is there any evidence in the record that the purpose of the statute was simply to raise money and that they just picked the closest target and it was driven by dollars and cents rather than some of these other interests?
There is no legislative history in this case, but the absence of a constitutionally tenable reason and the several years we've spent considering this case lead us to that conclusion, that this was a tax for the purpose of taxing, and that was the reason. And that does not pass constitutional muster.
The tax could have been avoided if he had adopted them, right? What difference how do we factor that into our analysis, or do we?
To answer your first question, yes, I think the tax could have been avoided if the decedent had adopted the stepchildren. The second question of how does it affect our analysis, if at all, I don't think it does, because for a couple reasons. First, yes, adoption is an option that's out there generally in the world under Chapter 600, but it's not an unfettered right. there are barriers to adoption in every case, and the general rule is that adoption begins with termination of parental rights. May I finish, Your Honor?
You may.
The second issue is, and perhaps the more concerning, in all of my research, I have not come across an equal protection case where the parties in the court agreed the statute violated the Equal Protection Clause, but nonetheless it was preserved because basically the bar could contract around the statute. I think that's what you'd be facing here. Thank you.
Mr. Priebe, thank you as well. Mr. Stanley.
Thank you. May it please the court. I think it's best to start with an overall big picture of the case. As Mr. Priebe said, the appellants are challenging the inheritance tax code, which is based on close legal relationships, that is by blood, by adoption, or by marriage. And they're saying in the marriage context, by not allowing stepchildren to inherit without tax if the marriage has been severed by divorce, they're being discriminated against, or
Well,
there's a
Mr.
violation.
Stanley, is it really close legal relationships or just legal relationships?
Well, I think
Is the
it's,
state interested in the closeness if there's if the legal relationship exists?
well, I think that's where some of the confusion in the case lies. It's not close in a personal way. It's that it's a close legal relationship, are the people who inherit without tax, and that is the children that are biological or adopted or by marriage. And I think I can maybe get to your point by making a couple of comments about the easel. We agree that these are accurate. We don't agree on the interpretation. In the first two, before there is an inheritance, because of a passing of one of the parents, the marriage is intact. On the third one, before there's an inheritance because of a passing of the parents, the marriage has already been dissolved. And that's why that chart is right, but the interpretation is wrong. The other thing that I think is really important about it, and is why I talk about a close legal relationship, is we agree with all the words on the third part except tax as if unrelated, because under the Iowa Code, these stepchildren from the divorced marriage are taxed just as Justice Mansfield said. The ex-spouse who got 23% in this case, she was taxed at this rate. If you have nieces, nephews, cousins, aunts and uncles, all of those people are taxed at this same rate, as well as strangers. So you don't have to be unrelated to be taxed in that way. There are a lot of people who are related. They're just not as close a relative as are children by biological adoption or during the marriage.
If you were to go through the RACI analysis, I think it's 3 steps. Some people say it's 4, but if you go through the RACI analysis, how can we uphold this on a heightened rational basis test that we apply under the Iowa Constitution?
Well, I think we would say that this is just a regular rational basis test. But even under RACI, there are several grounds that we argued, not 8, because some of these grounds are intertwined, and we've always said there were 4. And then one of the things they've done is say they're 8 and cut them in
Oh,
half.
Let me maybe tell you my concern. The first one, I think, as we set forth in Racy, you must not ask whether the ordinance serves a legitimate government purpose, but also whether the claim state interest is realistically conceivable under that purpose. So what's the purpose, and is it realistically conceivable?
The purpose, one purpose, and I think that's the one you've talked about the most, is the incentive to save and invest and to pass on the assets, whether it's a business or money or a farm or something like that, to the lineal descendants. Another purpose is not just to raise revenue. We've never claimed that that was a purpose in and of itself, but to raise revenue while having an equitable tax burden. And in this case, the legislature made a decision. It was equitable to have the people by the descendants by biological means, by blood, by adoption, and by marriage. It was a fair burden to have them get this exemption. Because of cases like blended families, like Justice Mansfield said, other things, to put them on parity and help out, those people all have the same. But when the marriage is broken, and I think this is where we get into the similarly situated argument, where I know I tread a little dangerously, but you know, it was true in Timberland, and I think it's true here, because in this case, the children are more in the same boat as unmarried people that might live together and have children, care for the children care for them, but there isn't a legal relationship any longer. An aunt and uncle will take
When you go to the next step, does the reason for treating these differently have a basis in fact? I mean, have you shown that?
I think that's what I was getting into, was that, and this is, you know, the analysis from Varnum that really similarly situated merges into the legitimacy consideration. And I think it's true because they have a different relationship now. They don't have the marriage bond, so they're more similar to families where there isn't a marriage. They're more similar to the aunt and uncle who may take in a nephew or a niece and give them great care and have great personal relationship. But I think the overall view of this case that I think is the most telling is that the whole discrimination theory is based on the fact that the current law doesn't consider the closeness, the enduring personal closeness that you have after the marriage is over. And the problem with that, and the remedy they propose, is they propose the remedy of once a stepchild, always a stepchild. And that, again, just like the law they're challenging, doesn't consider closeness at all. It's another bright line test. And in inheritance tax, it's helpful to have these bright line objective tests, because that gets to some of the other purposes that we talk about in our briefs. The uniform administration of this, the burden. If we had to go on every will and see, is there a close, enduring relationship, and that's the reason you get to inherit tax-free, that's an insurmountable burden for the state.
You got me there, no question. But I think it's fair to say that the other side in this case focuses not so much on the marriage relationship, but focuses on parent, stepchild, parent, stepchild, parent, stepchild. And the other side might well be willing to concede that you shouldn't have an individualized showing. They just think the rule ought to be different. And that they're really, because these relationships are so varied, and you know, there's the kaleidoscope of relationships between parent and step-parent is varied. Because they're so varied, the simple thing to do is say, treat them the same all the time, anywhere, any place, court adjourned. And the notion that the relationship is affected by a derivative relationship, that mom and, that the people aren't married, that in real life, that isn't necessarily true.
Well, I think it's reasonable for the legislature to believe, again, as Justice Mansell was saying, that after the marriage is dissolved, there's a chance that, where this could be the case with Ms. Tyler and Mr. Alcorn, we're not challenging that in their case. But as we cited a lot of cases, and in the Mueller case, for instance, it put out the caution that courts don't make determinations about inheritance tax and constitutionality on the basis of an ad hoc example. It's a
But is
policy.
it, okay, let me try this. Is it rational to believe that if there's a divorce, as there is in situation 3, that therefore there must be a change in the relationship between the parent and the stepchild? Is that, I mean, it's obviously not a one-to-one relationship, but, I mean, I think the basic rationale that I hear you saying is that if the parent and step-parent get divorced, that, for purposes of this statute, automatically means, clear rule, that the relationship between the parent and stepchild has been changed.
Well, no, I'm not saying that happens in every case.
I know you're not saying in every case, but is it even rational to assume, it may be overbroad and under-inclusive, but is it rational to say that a divorce, is it rational to say that we are going to treat the stepchildren differently in every instance where there's a divorce? Is that, I mean, it doesn't have to be a perfect fit, and we know all that, but is it a reasonable fit to say that when a divorce comes along, the stepchildren, for purposes of inheritance tax, are in a separate class?
I think for all of the reasons that we give, and some of them may be a tighter fit in reality than others, but I think the fact that the legislature could believe this is a rational reason for doing it, and it does have some basis in fact, and the fact that the code now isn't based on that personal affinity. There are biological children that don't get along with their parents. There are adopted children that don't get along with the parents. During the marriage time, that it could be both ways, and so it was reasonable that they do that. It's just that the legislature has chosen to make it a more close.
I mean, wouldn't it be fair to say that, I mean, the legislature is going to have to make, there are really 3 options, right? I mean, one is the assumption that divorce changes things. One is the assumption that divorce changes nothing. And then the middle is a case by case. And the legislature picked one of the 3. I think I'm the only one on this court, by the way, who has a blended family. So if I was asking questions, that may be why.
Well, and I came from a blended family, but what it does is, you're right, you have to pick one of those 3. And as Justice Sager said, there's a heavy burden here to negate all of this beyond a reasonable doubt. And I don't think it makes no difference at all over, it does make a difference. The appellants have met that standard at all. And what I'm saying is that if you just look at the closeness, that is administratively untenable. There's no way that we can get into every probate action and look to see if closeness is the test. And I think that's why, even though they argue closeness is the problem, their their remedy doesn't consider closeness at all. It just is another bright line test. And we have those all the time in inheritance tax. We have them on family settlements, the Bliven case. We have them on these kind of issues where you have a bright line test because that's what you can administer. I do want to, and I think we've talked about them a little bit, but in the reply brief, there are two new issues. One is this close relationship versus close legal relationship, and I think that did get a little muddled as we went through, but part of this is there is a inversion of the causal relationship. This inheritance tax benefit was instituted to help encourage close relationships. It's not a reward for having a close relationship. That wasn't the purpose of the statute. And secondly, about the similarly situated. And I think not only we have a dictionary definition, but we have other parts of the code, and this was part of the district court ruling too, where in section 252, A2 and A3 talk about the financial obligations during the marriage that a step-parent has. And in section 600 talks about the responsibilities and the rights of a step-parent during the marriage. And so that's why I say this is a little like timberland, because even though the apartments and the condos looked exactly alike, the decision was based on the bundle of rights that you have from the fee simple interest in the condo as opposed to the rights you have renting an apartment. And I think a step-parent during a marriage has certain rights and responsibilities that they don't have afterwards. And so the step-parent-child relationship is changed after there's a dissolution in the marriage. And I think, you know, aside from this, we just stand on our briefs. Thank you.
Mr. Stanley, thank you as well. Mr. Dutton.
May it please the court. Counsel, in 1997, the Iowa legislature reinstated the inheritance tax exemption for stepchildren. And the Department of Revenue
They reinstated, but Mr. Dutton, they reinstated it for everybody. Prior to that time, the only exemption was surviving spouse, right?
Well, that's correct, but the last time the Iowa legislature had given stepchildren an exemption from inheritance tax was 1911. So this was a dramatic act, and it was precipitated by the fact that farm income had reached a historic high in 1997. And as we know, in Iowa, the farm economy drives the legislature in terms of its ability to fund the government. And after the amendment was granted, and stepchildren now of all kinds were granted the exemption, the Department of Revenue said, we will not discriminate as to stepchildren whose parents have died, as opposed to stepchildren whose parents are divorced. In other words, across the board, they would grant exemptions for all stepchildren based upon their understanding of the law. In 2003, unfortunately, the farm income declined to a point where the Republican House and Senate were scrambling to find revenue for the government. So one of the things they looked for was some revenue source, and the closest one they found was the stepchild and the stepchild exemption. And that's what they keyed on in getting revenue back for the government so they wouldn't have to come out and say, we've increased taxes. And we know that's something that the legislature would hate to admit. So what they did is they simply redefined stepchild to exclude from that inheritance tax those stepchildren who had, in fact, parents who had been divorced. And the reason they picked on that particular exemption is that there is a bias in this state and in the world, actually, against stepchildren. That's a pejorative term that is applied to a lot of people, mostly by biological children who think they're somehow superior, based upon the myth developed by Cinderella and all of the ideas that the stepmother is an evil person and that the stepchildren are punished simply because they have fallen into her grasp. But the other thing that's most important here in terms of the mental attitude of the legislature is that until recently, and in fact still, there are religious groups that are prominent in this state who believe that divorce is a sin and that remarriage is adultery because in the eyes of their God, you have not actually been divorced. So this was a very easy fix for the legislature to simply say, we no longer will grant an inheritance tax exemption when the parents have been divorced. And they would seal that by saying, and quoting scripture, that the sins of the father are visited upon the children from generation to generation. Now, those statements we grow up with, we were taught, and that means that the legislature had those beliefs that would undercut and support that division. And what you're faced with here is whether or not that is a rational basis for distinguishing between stepchildren whose biological parent died and stepchildren whose parents were divorced. And I believe, and I think you can find that that is an irrational argument and an irrational basis upon which to make that distinction.
But counsel, if there's a problem with stepchildren not getting along with biological children or a bias against them in blended families, isn't this a good thing to allow a financial benefit for when the step-parent and other parent remain married? They keep that family intact, and that's supposedly one of the purposes of this exemption, that it promotes that family cohesiveness.
Absolutely, and that's the Brady Bunch example that now I think leads the fact that there are 1,300 blended families that occur every day in this country, every day. And there will soon be more blended families than there are families that are not blended in our society. So this is something that is a part of the reality that we're faced with and we're going to have to deal with. And this is not the point at which we say we're going to go old school and we're going to punish these adopted or these stepchildren because of the sins of their parents, i.e. that they got divorced. That's wrong-headed, and it's not right, and it's not constitutional. Thank you very much.
Mr. Dutton, thank you as well. Case of Paula Tyler versus Department of Revenue is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.